So I'm just going to make it. So this is a little unorthodox today. We generally start our hearings at 1 p.m. Because we had a long floor debate. We're starting at 2:15, which means we're going to vote now here. So obviously everyone here is welcome to stay, but you're just going to, folks, the senators will have their lunches in front of them, and we are going to be voting before we go into our bill hearing. So everyone's obviously welcome to stay, but just want to make sure everyone's aware of that. And we apologize for the delay, but we had a longer floor debate than we anticipated. So it's pushing our schedule to the right a little bit. So thank you all for being here. All right, welcome everyone. We're gonna tackle 3 bills on a voting list today. So just for the record, today is Tuesday, March 7th, and we are on voting list number 7. We have 3 bills: Senate Bill 1, Senate Bill 185, and Senate Bill 858 that we will entertain today. We have 2 people at the front, Mr. Pennick and Ms. Herron, who are here to provide technical expertise if we need it, additional technical expertise if we need it. This is not a bill hearing, so we're not going to kind of relitigate the bills, but if there are hyper specific questions that you all could assist with, then we will engage you. So I just appreciate you willing to lend your expertise to the committee if we need it. Other than that, I think we're ready to go. So I'll kick it off to council. We're going to start off with Senate Bill 185. Also, just another PSA. This is kind of unorthodox. Our floor session ran late, so you'll see the senators will be eating, and after the voting session during the hearings, folks are going to be leaving to attend to other business and also eating. So just be mindful of that. So, all right, Jamie, go ahead.
Thank you, Mr. Chair. Senate Bill 185 expands the purpose of the Maryland State Police Gun Center to include the tracking, screening, and vetting of all firearms surrendered under final protective orders in the state. The bill requires the center to create and maintain a statewide database to track information on firearms surrendered under final protective orders in the state. And each law enforcement agency is required to report to the center certain information on firearms which were surrendered under final protective orders issued in the jurisdiction of the law enforcement agency. There are no amendments.
All right, questions from the committee? There's been a motion for a favorable. It's been seconded. Further discussion, questions? Do we need a roll call? All right, Senate Bill 185 passes unanimously. All right, next we'll go on to Senate Bill 858. There are substantial amendments, so I'll have council read them and then we can walk through. And then also for the folks at home, it looks like we're having trouble with our camera. We can notify DLS, then we'll be forward, but I think you can hear our voices and we'll make sure that the microphones are on at all times. All right, Jamie.
Thank you, Mr. Chair. Senate Bill 858, as introduced, modifies and expands an existing prohibition related to a child's access to firearms. Additionally, the bill, as introduced, requires the Deputy Secretary of Public Health Services to develop a youth suicide prevention and firearm safe storage guide by January 1st, 2024. In fiscal 25, the governor, and this is as introduced, must include in the annual budget an appropriation of $1 million to the Maryland Department of Health for the development of the guide and funding to grants to support the education of families on safe firearm storage practices recommended in the guide. There is an amendment before you. It is Amendment 723-327/1. That's for Senate Bill 858, 723-327/1. The amendment, the reprint for the amendment is behind the text of the amendment. The amendment strikes provisions of the bill on the first few pages, and then if you get to bill page 4 of 7, the new text being added is included. This alters the reckless endangerment statute under 3204 of the criminal law article and would provide that a person may not recklessly leave or store a firearm in a location where the person knows or reasonably should know that an unsupervised minor or a person prohibited from possessing a firearm under state or federal law has access to the firearm. Offenders would be guilty of a misdemeanor and subject to the existing penalties for reckless endangerment, which are 5 years and or a fine not exceeding $5,000.
Can you differentiate between what this is and the current reckless endangerment statute?
Right. So the current reckless endangerment statute, I'll just read the text of it to you. Provides that the current reckless endangerment or the current safe storage statute?
Just because people say like, hey, we already have reckless endangerment, isn't this your statement?
Sure. So the current reckless endangerment statute under 3204 provides that a person may not recklessly engage in conduct that creates a substantial risk of death or serious physical injury to another, or discharge a firearm from a motor vehicle in a manner that creates a substantial risk of death or serious physical injury to another. So this is a third component specifically relating to storing or leaving a firearm recklessly. Is there anything you'd like me to hit next on?
No, you could do so just differentiate between the prohibited person for the offenses. So like if you're a second offense, are you going to walk through?
I was going to go through the
no,
entire
sorry.
bill.
Sorry,
Yeah.
go ahead.
So if you go to the bottom of page 4, that's where the exceptions start for the reckless endangerment piece. At the bottom of page 4 provides that subsection A3 of this section does not apply in the following circumstances. That would be the minor accesses a firearm for self-defense or the defense of others against a trespasser into the residence of the minor or into a residence in which the minor is an invited guest, or the following 4 criteria are all met. The firearm is a shotgun or rifle. The minor has a certificate of firearm and hunter safety issued under 10301.1 of the Natural Resources article. The minor has permission from the minor's parent or guardian who is at least 18 years old to access the firearm, and the minor is not otherwise prohibited from possessing a firearm under state or federal law. So all 4 of those criteria would need to be met for that exception to apply. Further down that page that we're on right now, the bill makes changes to the existing safe storage statute. Starting off, the bill changes the existing safe storage statute under 104 of the criminal law article to, instead of applying to children, which are defined as individuals under the age of 16, it would apply to minors, those being individuals who are under the age of 18. And the text of the bill provides that a person may not store, or excuse me, the text of the statute would provide a person may not store or leave a firearm in a location where the person knew or should have known that an unsupervised minor or person prohibited from possessing a firearm under state or federal law would gain access to the firearm. So the changes being made there are under current law, in order to qualify as a violation, the firearm would need to be loaded under the statute. That is removed. As I mentioned before, current law applies to a child, so somebody who's under the age of 16. This applies to minors, and then it includes access by a prohibited person. The penalty remains the same for this, but on the following page, subsection E, which provides for evidence of a violation. Current law prevents the violation from being considered as evidence in negligence. This repeals that provision. Below that, there is an anti-merger provision. So the reckless endangerment statute, or excuse me, the child access prevention statute would not merge with any other conviction for the same set of facts or a crime based on the same set of facts. The sentence could be imposed for any of those offenses consecutively or concurrently. Moving on, the bill retains the requirement for the development of the firearm safe storage guide and suicide prevention guide. On page 6 of 7 of the reprint, the guide is required to be, in addition to the individuals identified in the bill as drafted, the guide is also required to be distributed to instructors who have been licensed or certified by the Department of State Police to teach firearm safety training courses. The amendment strikes the $1 million budget appropriation that was in the bill as drafted. Instead, well, there's a tax credit, but actually just I'll go in order of the bill here. The amendment also alters the circumstances under which somebody is prohibited from possessing a regulated firearm under section 5133 of the public safety article. Specifically, a person would be prohibited from possessing a regulated firearm if the person has been convicted of a second or subsequent violation of 4104 of the criminal law article, or has been convicted of a violation of 4104 of the criminal law article if the violation resulted in the use of the loaded firearm by a child, causing death or serious bodily injury to the child or another. So those two circumstances are differentiated because it's either the second or subsequent, or it could be the first if the firearm was used and resulted in death or serious bodily injury. Just a technical note, the reference to a child should actually be changed to a minor.
Oh, sorry, Roman 2.
Right, so that would be on bill page 6 of 7 in Roman 2. That'll need to be changed to a minor since that's what the statute will apply to. If you skip 2 pages, it's an unnumbered page, but subsection G is at the bottom of the page, 2 pages from where we were. Provides that a person who has been convicted of a violation of 4104 of the criminal law article, which is the safe storage statute, may not possess a regulated firearm for 5 years following the date of conviction. Turning to the next page, if you look midway through the page, there is a provision that provides for a tax credit for equal to the lesser of either 100% of the purchase price of a firearm safety device or $250. The tax credit can be claimed only once. It is a refund tax credit, and it'll be applicable to all taxable years beginning December 31st, 2022. And that is the amendment.
So I think the good thing about this approach is that it balances the realities of, Heller and post-Bruin constitutionally, and also the actual realities, just from my perspective, just more firearms in Maryland. I mean, we talk about the number of actual wear carry permits that have been issued since Bruin came down, which is over 100,000 since the Bruin decision came down in June. So I think this is that balanced, more nimble approach that we discussed during the hearing. But I do want to, open it for folks to. Everyone's seen this bill, but I want to open it up for questions if there are any.
Thank you. I'm sorry. I'm wondering whether, since the bill has been much changed since the hearing, I wonder if it would be appropriate for me to ask one of the people here at the trial table, with the witness table, whether or not what his view of the bill is at this point. It would be helpful, I think, to get his analysis. Okay, thank you. Mr. Penick, would you be willing to share with us your analysis of this bill as amended?
Sure. I have 2 copies of SB1. I don't have a current copy of the latest version of 858. So, and I've gotten a very much earlier one. So to the extent I can get a current copy, that might help.
Watch my chicken scratch on it. Feel free to repeat any of the chairman's. Yeah, let me get my chicken scratch back. Sorry. Secret notes. Oh, darn. For the record. Right. Do you have it?
I do have it.
Okay. Thank you.
So initially, I want to congratulate the chair and the committee on removing the unconstitutional provisions that were in 4-104. The amendments to the reckless endangerment statute are severe, but undoubtedly constitutional, as long as the retain the statute, the limitation. I'd like to take a moment just to be sure that I have has access to the firearm. I'm wondering if a better amendment might be to a loaded firearm rather than to simply the firearm, because a loaded firearm is the one that poses a reckless endangerment. An unloaded firearm is just a paperweight. But you know, that's consistent with the idea of this being a reckless endangerment. The other provisions that were changed to are unobjectionable in 4-104, except to the extent that it poses a lifetime or even a temporary disqualifier by virtue of a violation of 4-104. That still is a non-violent misdemeanor. And there is an open question in the courts right now as to what extent the state has leeway to impose a disqualifying offense with respect to a non-violent offense. So that's at issue right now in Bank and the Third Circuit and Range versus United States. A number of other courts have opined on this while. It's currently before the Fifth Circuit in the G3, 922 G3 context. So it's being heavily litigated right now. I alert the committee to that possibility, is to the extent that it wants to consider whether or not that's a good idea. But you know, that's your call to make. I think it's likely that a disqualified person will bring suit to challenge that disqualification. So to the extent that you're imposing that disqualification under 5-133, that strikes me as a long-term disqualifier, not simply from the permit itself. I mean, that's bans the possession of anything. So that's a risk that the bill now takes that you should be aware of.
Mr. Pennick, admittedly, I only had a few minutes to glance through the bill as the committee counsel was describing the changes, but it looked to me as if the disqualifier was for a second offense.
Well,
It's a
so
provision,
on
it's a
the,
5-year disqualifier for the first as well.
But that's not permanent. It's 5 years.
It's for 5
No.
years, but again, that's a disqualifier.
Got you. Okay.
So,
Thanks.
and you really can't differentiate disqualification for purposes of a permit and for purposes otherwise, because after Buren, the permit is a constitutional right. So that's the risk that's being taken with this bill.
Okay. Thank you.
You need to respond. So. I don't suppose I have a whole lot to add. I think the changes that you've made to the bill, I know you know my standpoint on this. We need to be addressing those older teens. This bill does that. We need to be addressing whether the firearm is loaded or unloaded. This bill does that. You know, some of the semantics about how you're getting there, I'm comfortable with. I'll leave it at that and not take up a whole lot of time, but I appreciate the opportunity to speak. And I'm certainly willing to answer some questions if anyone has any.
Thank you, Mr. Chairman. So the reason that we changed it specifically from minor to child to up the age from 16 to 18. And
Technically the other way around,
I'm sorry,
from child to minor.
or from child to minor. I'm sorry. Thank you. So, and the reason that was done was, and it doesn't matter if they have because now it involves any firearm. Limited exception. Oh, to only shotgun and rifle. So are we gonna? So we're not going to do anything. We're going to leave it. We're striking out the loaded portion of the firearm. We're taking that out, and there's nothing, because it is specifically and wholly different to have a loaded firearm or access, even having it close by, versus when you're cleaning your firearm and it's sitting out. Loaded is an important element in reckless.
Good. I'm going to have the council read the definition of recklessness, but also just for a policy matter. Also, if you have the magazine close by, or it's just for a policy matter, just this is I think the policy direction that is proper here, because if you have ammunition or a magazine close by, then it's not immediately operable, but near immediately operable.
Wouldn't there be a way to, we find ways to cleverly put things in wording into law, and, you know, the world we operate in, words are important. So when we just say, and we strike it out altogether, you could have a firearm in a house and have no ammunition anywhere in the house and be in violation of this, of a paperweight. And I'll go a step further. So for example, when I retired, I was awarded my firearm I had carried the entire time. It's not an antique firearm, but if that's hanging on the wall behind my desk because it's been engraved and is something that, you know, protected me and others for a number of years, even if I don't carry another gun in the rest of my life, by the way this bill's written, I would be in violation of this. Because it's not historic, it's not antique, and there's no ammo. So that would be one area that I'm pointing out a concern at, just obviously just seeing this for the first time since these changes were done. I do have a question about the prohibited persons. We made a prohibited person for the storage precautions. For the minors, but we did not do, and having exceptions for them to have access to said weapon or firearm in certain circumstances, but there was no such exception for a prohibited person. So we have it requires the same storage precautions to prevent access by a prohibited person as they would for a minor. But when we did the circumstances for exceptions, as I'm seeing it, that the storage requirement for minors to use the firearm in certain circumstances applies, but that same exception is not passed along to a prohibited person in those exceptions should that same situation arise.
I don't know. The person's a prohibited person, so there's no circumstance in which that person. I don't know anywhere.
You can, yeah, there's no circumstance, but we have it to where there are. So we're not going to have, if the person's in your house and there's nothing, there's no action that so we're not going to have anything parallel for the. Okay, all right. I'm just asking for clarification, make sure it wasn't missed. And then really that's my biggest concern is that we have the loaded versus unloaded. I know that we moved it to 18, but it was left out for the rifles and shotguns, which would be consistent. But is there any, and I'm asking because I'm trying to review this and ask you at the same time, if they're below 18 and have this hunter safety class, they're still not allowed to have access to this?
Right, Senator. So let me just pull up on the reprint here. So if we're looking at the page of the reprint after page 4,
So
those are the exceptions. They'd be both the exceptions for
where are you talking about? You said after page 4. but
after the page. It's unnumbered, but it's immediately after page 4.
Well, the copy I have says 4 of 12, and then it says 5 of 12. And then it says 6 of 12. So you're
So
talking about the original one?
no, actually behind, so I think the pages that you're looking at, Senator, are the actual text of the amendment.
Okay,
If you go in the part that you're looking at and just after page 12, you'll actually see the reprint of the bill.
all right. So after page 4,
So it'll say bill page 4 of 7 on the reprint.
Mhm.
If you go to the bottom of the next page,
okay,
it says these are the exceptions to the prohibition. So it wouldn't apply in Roman 1 if the minor accesses a firearm for self-defense or defense of others against a trespasser into the residence of the minor or into a residence in which the minor is an invited guest. So that's one exception
Where-
by
where-
itself.
It's the bottom of the.
you're at the, which numeral? We've got, like- okay,
No,
all right.
No, I'm sorry, Romans 4, number 5, under 5, right?
Above 5?
I think we're on different pages. I think no, we have the same one, but I'm looking at the exceptions under 3204, but they should match up between 3204 and 4104. But basically looking at the top of the page, Roman 1, the minor accesses the firearm for self-defense or the defense of others against a trespasser into the residence of the minor or into a residence in which the minor is an invited guest. So that's a standalone exception.
Okay,
The other exception, you've got 4 Arabic numerals, 1, 2, 3, and 4. All 4 of these would need to be satisfied for this exception to apply. So first, the firearm would need to be a shotgun or a rifle. Second, the minor would need to have a certificate of firearm and hunter safety issued under that provision of natural resources. Third, the minor would need to have received permission from the minor's parent or guardian who's at least 18 to access the firearm, and the minor could not otherwise be prohibited from possessing the firearm under state or federal law. So that's an and. All 4 of those would need to be satisfied for that this exception under Roman 2 to apply.
okay. So and I'm just this was something that just came across a report that I got where in Baltimore, there was a young man being chased by his father. They both apparently each had knives, and he runs up to his room and he ends up shooting and killing his father, unfortunately. He was 19 years old. So if that is the case, and there's many other things that I'm not familiar with on that case, so I'll put that out there first. But as I'm reading this, if that is a handgun that was used, he would be in violation of the law, even though it would be deemed self-defense.
The I guess in that factual scenario is the victim of the crime is a prohibited person.
I'm sorry, he's
It-
19, he can't carry a pistol.
He's 19 and can't carry a pistol. So the 2 statutes that are being changed in front of you would not apply to that individual because he is at least 18. He's not a minor. He's 19. But
But he's
under
a prohibited person.
he's prohibited under 5133 of the public safety article under a provision that restricts possession of handguns or regulated firearms from people under the age of 21. That's correct. But under 5133 of the public safety article, there's an exception that actually I think I made it just from a drafting perspective verbatim for accessing a firearm for self-defense. So a person under 21 can access a firearm for self-defense or defense of others against a trespasser into their residence or a residence in which they're an invited guest. So that.
But it's not
I
a trespasser,
believe-
it was his father.
I'm sorry, what?
It's not a trespasser, it was his father.
You're right. So in that case, 5133,
Would not apply.
the literal provision of it wouldn't apply.
So
That's existing law.
in that one, as this is written, with that young man who was chosen not to be charged, as I understand it, by the state attorney's office, would that young man be now punishable under this new guideline?
Well, the prohibition that's in this applies to the person who stores or leaves the firearm. Not so what's being punished is the person who is the offender is the person who stores or leaves it. Not specifically in this the person who accesses it. So in that scenario, I think it would apply to the. It's a tough scenario because we're not dealing with
But
somebody
it's a
who's
real
under 18.
scenario.
Well,
That's the problem.
it wouldn't apply, I think, in that situation because you're not dealing with a minor in that situation. You are dealing with a prohibited person.
Right, which is what I asked earlier.
So
Why the
I guess it
prohibited
depends
person was excluded in the circumstances that were given
right,
because we didn't leave them in as an exception.
right.
But I'm bringing forward, and I'll be happy to share it with the chairman because it's privileged information, but I'll be happy to share that with him to show him this situation that just happened this past weekend.
Sure. So I guess to the question, I think the prohibited person being the 19-year-old in that scenario
Mhm.
wouldn't be subject to this because they weren't the person who stored or left the firearm.
Just keeping it with access to the guy's owner or story.
Okay.
Mr. Penick actually has my copy, so I'm operating from memory here, but as I recall, the language in the beginning says that it's illegal to leave a gun where a minor could get it, except if the minor gets it in order to use it against an intruder, then it is legal. That sounds weird that it's illegal to have the gun where a minor can get it, but if the minor does get it and uses it against an intruder, then it was legal all along. I guess that's what it means. The language means it. Isn't there a better way of expressing that? It's like retroactively, we're deciding that an illegal act in fact was legal because the minor got the gun and used it against an intruder.
I think it's the circumstances of if it actually happens, then, under these conditions of trespass, then you're kind of absolving the owner of the firearm. So, that's a policy call, but I understand that. I still don't think, I don't know how you answer that question through statute. I don't know how you would draft an answer to the question.
I'll take a whack at it, but is there some reason why we have to vote this bill today? Could we hold it till Friday or Thursday, whenever the next, floor amendment? Okay. What about the issue about if it's just a gun, no ammunition, and it's nothing more than a paperweight, that's illegal? What, are we going to do something with that? Or is that another?
You can offer an amendment.
Another floor amendment?
I think that you can offer an amendment on that. I think it's, again, that's a policy thing. I mean, in terms of having, you could have
So Senator Folden,
a magazine to expire ammunition. Say it again.
Senator Folden, if we leave this bill the way it is, you're gonna have to take the gun off his wall and put it in safe. You can't, even though there's no ammunition anywhere nearby, he still can't have it hanging on his wall.
I think that's entertain the floor amendment, but yeah.
Actually the point that I wanted to
Yeah.
Chairman, so as a parent of a 15-year-old, I was looking at this closely when you were giving your scenario, Senator Folden. So I guess maybe it's for council, but
So I'm thinking just from a parent's rights perspective, because I don't think of it as a paperweight. I think of it as more than half of a deadly weapon. And for me, I would be very uncomfortable with my child, and that's okay. Like, we can have different views as parents, but I think the language is pretty clear, right? This section does not apply if the minor has permission from the minor's parent or guardian who is at least 18 years old to access the firearm, correct?
As long as all four of the
Right, the other
conditions are
criteria,
met.
right.
Right.
So in that situation, he wouldn't, with his own children, he can do what he wants as long as they meet the other criteria.
I'm sorry, so I understand the question. What was, I guess, could you repeat the question on
As long
that?
as all the exceptions.
Yeah, as long as the exceptions are met, he doesn't need to remove the unloaded firearm off his wall because he's the parent
Right.
and he can give
And
permission.
He can give permission, and as long as the minors have a certificate of firearm hunter safety, they've got the permission, they're not otherwise prohibited, and the firearm is a shotgun or a rifle, then
Not apply to my scenario because they are automatically by their age a prohibited person. So that's.
But
I-
they're
I
a
don't wanna-
minor.
I don't want to confuse this. If, once they're a prohibited person by age, they're a prohibited person. So you even said it has to be all four of those criteria. And by age, they are a prohibited person. So therefore, they cannot have access to that in the way this is crafted, unloaded or loaded.
Well, Senator, if I might be mistaken here, but I don't think I am. The age prohibitor under state law would apply to regulated firearms, not shotguns and rifles under 5205.
Right.
So
But
there
we're
isn't
talking about
actually a
pistol. Talking about a
right.
pistol.
Oh, if a,
That's what we've been talking about the whole time.
no, my impression was, is it a pistol that was
No,
on the wall?
yes.
Or
My pistol, my duty
Oh,
weapon.
sure,
That
if
my
it's a
kids have
pistol,
seen me walk in the house in and out of every day for my entire adult career.
sure, the pistol on the wall wouldn't be covered by this exception because it applies only to shotguns and rifles.
That's what I'm saying.
So I guess, never mind. I think I understand my point, but my larger point still remains, which is that while there are some, to the point of the policy consideration and parents' rights, I really feel really strongly that just because something is unloaded doesn't mean it's not dangerous. So that's my perspective and why I'm supportive of that policy position.
So I just want to, thank you, Mr. Chairman. Just want to make clear that the word loaded or the word loaded now or unloaded now is both part of what is this? This is hard to read. 4-104C, that's correct, right? And then it's in one other section, right?
The page preceding, Senator, I think 3204.
204. Okay, 3 also, right?
Right.
So I think the thing that Senator Folden is expressing, I just want to give you an example in my own house. We probably have 15 to 20 firearms in my house, mainly because my house is so old and people just leave stuff there. So my husband does like to collect a few more recent firearms, but we have a lot of old firearms. I have no idea if they're antiques. Not all of them are. They have no ammunition. And as I understand this bill, so let's say it's a 1950s, I wish my husband were here, he could tell you what these are, 1950 something or other. We have no ammunition in the house. We had 3 or 4 of these, let's say. All right, 1973, no ammunition anywhere. We have minors in the house. If the minor does not have a hunter safety certificate, just that one requirement, which let's say none of my kids are interested in, which they're not, then we would currently, with this bill passed, my family and I would be in violation of this law. And then, and then I have a question for after that.
Sure, if any of those 4 criteria are not met, then it would be a violation.
So the question I have is, how does this advance safety in my home?
So
There's no ammunition at all. My children are, I guess, 17, we'll just make them all 17, 18. They don't have hunter certificates. And this, by the way, this was throughout their entire childhood. So this has been going on for 17 years. So I just want to understand how this makes the situation in my house safer. All right, but do you want to try?
I'll just highlight one point. I mean, this bill is designed to protect children. But in addition to that, by securing your firearms, you've just announced on, public television, basically, that you have a lot of unsecured firearms in your home. So the
Which I'm
theft
fine with.
of those firearms are going to turn these into crime guns, right? So if
I do
you
wanna-
secure
all right.
them more.
Let's, I don't want to turn this into a bill hearing
Sure,
again.
sure.
So, all right.
Yeah, I want you to address.
No, I think
issue.
that's,
How it would be.
that's
safe
a
under
Senator
this.
James, valid
sorry.
question. No, that's what I just, that's, I don't want to get into a bill hearing.
No, I just wanted to ask her a question.
Oh, sure. Okay, you're good. Stu.
So I was like,
No, got it. Yeah. Go
if
ahead.
you could go to so the same question I asked
I'm gonna,
our staff, then I thought you were gonna get up and rather than say what you did, you might help with the answer to your
Well,
question.
I mean, I'll try not to divert too much, but the idea that safe storage makes all of us safer is really underlying this entire piece of legislation. It makes our children safer by not allowing access to the youth in your life who are coming into your home so that they can't bring these firearms to school, whether they're loaded or unloaded. It isn't as hard for children to get the older teens that we're wrapping in, right? It isn't as hard for them to get their hands on ammunition, even if it's not in your home, even if it's not in their home. So
Yeah.
that's where it gets
I just
to.
want to, I don't want to get to the, yeah,
Okay.
it's just not a technical question, but so I think Senator James, you asked a valid question. And I think we should entertain your,
The only thing I was thinking is maybe,
yeah.
I think I applaud the effort on this bill. But I want to make sure when we're going fast, that we just think everything through. I don't know if we could say with this criteria that we could do an and or someplace. Because, there's a lot of young people in the world I live in that are proficient with firearms, but may not have this certificate. And I just don't want this hyper technical requirement. I was just wondering if there's a way that we could do and or something like that. So because that's the only one I'm really hung up on right there is just all 4 of them have to be there, and whether or not we could make a reasonable combination, because I respect what the advocate just said about trying to just make the situation safer. And then my last question is our concern about whether it's loaded or unloaded, the idea that it would be difficult to legislate the issue of if there's no ammunition around, obviously, I don't think the gun is as unsafe, but is it the idea that we just don't know how to legislate whether ammunition is nearby? So we just want to sort of make it a broader requirement.
I mean,
Is
I
that
think
the
that's-
thinking?
That's exactly what I was talking about with Senator West earlier. It's just hard to be as prescriptive but I do understand, I mean, in the other extreme, I'm not all the way at the other extreme either as a sponsor bill, but I understand that if there's no ammunition or even on the property, then hey, I get it. Like, we all get that. So I think, there is probably a path forward here.
Yeah, I think so.
And we can work together to be a little bit more precise on that. I
Thank
agree
you,
with you on
Mr.
that. And you have my promise to work on earnest on that for both of you. Senator West and Folden.
I guess my first question to the chairman is, if we have to pass this bill today, when are we going to work on that?
So here's what I would do. I would say, let's adopt this amendment now, advance the bill, and the 3 of us will work. Senator Folden, Senator James, Senator West, whoever else wants to join, and we can work in on tightening it up, because I think we're very, very close, but we have a timeline to keep. I am going to advance this bill today, but you have my promise that we will work to resolve those lingering issues, because I think they're valid.
Okay.
But that's what I'd like to do.
You won't be upset if some of us vote against this bill at this point.
No, understood.
Hoping we can tighten it up,
But
and maybe.
But understanding a forthcoming floor amendment, we will engage and work. I mean, I get it.
Okay.
I understand
thank
that. Senator Foley.
Thank you, Mr. Chairman. So I just want to also be clear. So Jamie, you might be the person to answer this. So when I look at the penalty portion of this, it talks about someone, a person who violates this section is guilty of a misdemeanor or reckless endangerment and subject to a penalty of up to or not exceeding 5 years. What's the current guidelines for punishment for a felon in possession of a firearm, loaded or not, above the age of 21?
Talking about under 5133 of the public safety article.
Yes,
So did you say felon in possession or just 21 is the age prohibitor?
No, if you're over 21
Right.
and you're in possession, you're a felon, convicted felon, and are in possession of a firearm. Are you familiar with the current?
Yeah,
Penalty-
under
what the current penalty is?
5133, I think it's D. I might be mixing up the section though. I know that there's a 5 without. Are you talking about 4204, the criminal article?
I'm talking about criminal law. Under criminal law,
Right.
if a person, a felon, convicted felon is in possession of a firearm, loaded or not, what is the penalty for that person in possession
Well, it
of that firearm?
depends on, I think
There's
to
no
give you
other
the best
factors.
answer, I'd need to know which section of law you're talking about because,
If you're a convicted felon
uh-huh.
in possession of a firearm, regardless if it's loaded or not, if you're in possession of a firearm, you are a prohibited person. A prohibited person, 21 or older, the penalty in the state of Maryland for being in possession of that firearm is what?
Let me
Senator, I
just pull
can
this.
answer that question.
It's 3 years.
For long guns. So there's a distinction in Maryland law between a felon in possession and a disqualified person in possession.
Okay.
They're not the same.
Okay.
So if you have an existing felony conviction, the penalty for possession of any firearm is 5 to 15. If you're a disqualified person and you're found with a firearm, it's 5.
Okay.
And the federal law is still different.
Okay. So where's the part where it's a 3 year? What's
3
the
years
offense?
is a disqualifier for possession of a long gun. And that's
If
found
you're a
in-
prohibited person, period,
correct,
and you have a long gun, it's
Right.
3 years.
3 years.
Okay, that's what I was trying to get and figure out. I apologize, Jamie. So that's what I want to know. So we have this, we have someone that can be a felon or a prohibited person by a felony. They have a long gun. They're in commission of a crime even. Doesn't matter because they have an actual intent to cause harm. That penalty is 3 years. This one, for a reckless endangerment, we have a penalty of up to 5 years for a first offense. So I'm just pointing out that it just doesn't seem altogether comparable. So I would be open to, if anybody wanted to, increase the penalty on the other side. Just throwing that out there as a friendly amendment for y'all. For the other bill though. And then, some language we might want to consider also is something that is constantly beat into law enforcement's head about going home with young children around, and that is inoperable and inaccessible. Those two words are very easily and clean if you look to incorporate them somewhere into this language. And that I'll just throw that out there because we're obviously not going to take any amendments today. Thank you.
No, I like that. And I appreciate it. It's good. All right, well then here's Senator Washington.
Thank you, Mr. Chairman. I was going to ask a question about the scenario that I think Senator West and James brought up about having a gun that's unloaded. No, there's no weapons there, but I'm just having it on my mantle. What was the amendment that you guys were considering?
So there's differentiation between a long gun and a regulated firearm. And so his scenario is his old service pistol that you had. And that's where the problem lies for loaded or unloaded, because that scenario is covered under this bill. And so we're gonna work. It would be a prohibitor, correct. So we're gonna work on something to resolve that incongruity, because I mean, I get it. No, I understand. I get it. And I mean, one of the You know, one of the things with gun policies, like you gotta kind of like, it's hard, especially, look, I live in Montgomery County, but I gotta get out of 495. So I gotta understand, you know, the entire state and different cultures, but we ultimately want to keep everyone safe. So I understand that scenario. It's a valid point that was brought. So I get it. We will work.
I just wonder if that amendment passes, whatever you guys come up with, I trust that you guys will come up with something good quality. But I guess my major concern with is the ability for a teenager or whomever to have access to it and then use it, take it to school or wherever and have it and then intimidate other students, even if it's unloaded. And I hope that the bill doesn't take away from that piece.
No, I get it. And that's why I opened up talking about just the new realities of Heller and Bruin. It's just, we're trying to get as close as we possibly can, you know. I wish we had a different Supreme Court too, you know?
Yeah, I like where we're
Yeah.
going with
Yeah,
the
yeah.
current bill. I just think if changing that,
No, I get it. No.
I just have some concerns with that. So thank you.
100% valid. All right, no. But let's do this. I'd like to adopt the amendment, just so, because we've been talking about this amendment. Can we adopt what we've been talking about in concept? Is everyone okay with that? And second, it moved, seconded, favorable, everyone's okay. All right, so just make sure I have this right. There was one question about the first offense prohibitor of up to 5 years. There was a question there. I like that. I like that. Even for the first offense, but can talk about maybe going to 3, but let's keep it. I like that piece. Then the second piece is the regulated device, unregulated firearms, unloaded, loaded. And right now it's unloaded, and the language, and it's every firearm, both regulated and unregulated. So that's another issue to resolve. With that understanding that we will take that and try to work on that for a floor amendment. I understand that there are members that cannot vote for the bill that in its current posture, but you have my word that we will work on it for a floor amendment, because I do need to advance this bill. I would ask for, with those two caveats with that understanding, I move for favorable with amendment. It's been seconded, and we can do a roll call. Then, and that we may get to 100% yes, or we may not, but we're going to try. No, I understand that. We're gonna do a floor amendment, but I understand that, you know, on the floor, we may get there, but. All right, so let's do roll.
Vice Chair Waldstreicher.
Yes.
Senator Sidnor,
Yes.
Senator West,
No.
Senator Muse.
Yes.
Senator Fulman,
No.
Senator Washington.
Yes.
Oh,
Sorry. Yeah, you got it.
Yes.
Senator James. Senator Kelly,
Yes.
Senator McKay,
Nay.
Senator James,
Yes.
Chairman Smith.
Yes.
So it's 7-3 with Carver up here.
Got it. So the bill passes 7-3. Okay, excellent. Now we'll move on to Senate Bill 1.
So as originally drafted, Senate Bill 1 prohibits with specified exceptions a person from knowingly wearing, carrying, or transporting a firearm under real property of another unless the other has given express permission either to the person or the public generally to wear, carry, or transport a firearm on the real property. Additionally, the bill as drafted prohibits a person from knowingly wearing, carrying, or transporting a firearm within 100 feet of a place of public accommodation. A violator of either prohibition is guilty of a misdemeanor punishable by imprisonment for up to 1 year. There is an amendment in your voting packet The amendment is Amendment 723020. So if you go past page 723020, Senator. If you, the first part of your packet, that's stapled together is, just like with the one before, the amendment text. You have to go past that. So past what's marked as page 23 to get to the amendment reprint. So, with the reprint, I'll just go in order here. If you go past the first two pages, so we're on what's marked in the reprint is bill page 3 of 3. The new text begins. In this text would establish locations where a person would be prohibited from wearing, carrying, or transporting a firearm. Generally, there are 3 places, there are defined terms where a person could not wear, carry, or transport a firearm. Those would be areas for children and vulnerable individuals, government and critical infrastructure areas, or special purpose areas. Again, those are defined terms under the bill. I'll go back and explain what each of those defined terms are. Generally, a person would be prohibited from wearing, carrying, or transporting a firearm to those areas. There's also a prohibition on a person wearing, carrying, or transporting a firearm into those areas with the intent to cause death or injury to another. A person who violates just the wear, carry, transport prohibition for a first conviction would be subject to up to 90 days or a fine not exceeding $3,000 or both. For a second or subsequent conviction, there's a typo here, should say not exceeding 15 months. Months was left in there, or days were left in there. So that would be 15 months or a fine not exceeding $7,500 or both. Or even on a first offense, if the offense was committed with the intent to cause death or injury to another, that would just be 15 months and or $7,500 fine. So I'll go over what each of these areas are or mean, the defined terms. So I'll start with an area for children and vulnerable individuals. That would mean a preschool or pre-kindergarten facility, a private primary or secondary school, a youth camp, a healthcare facility, or a location being used as a shelter for runaway youth. So the next area that's a defined term would be government or public infrastructure areas. Those mean a building owned or leased by a unit of state or local government, a building of a public or private institution of higher education, a location being used as a polling place in accordance with Title 10 of the election law article, or for canvassing ballots in accordance with Title 11 of the election law article. Or finally, an electric plant or electric storage facility is defined under the Public Utilities article. The third area, a special purpose area, means a location licensed to sell or dispense alcohol or cannabis for on-site consumption, a stadium, a museum, a location being used for 1, an organized sporting or athletic activity, 2, a live theater performance, 3, a musical concert or performance for which members of the audience are required to pay or possess a ticket to be admitted, or 4, a fair or carnival. It also means a racetrack or a video lottery facility is defined under the state government article, and also means area within 100 yards of a place where a public gathering, demonstration, or event which requires a permit from the local governing body is being held if signs posted by a law enforcement agency conspicuously and reasonably inform members of the public that wearing, carrying, and transporting of firearms is prohibited. So there are also circumstances to which the new section of law would not apply in any of those three areas. So it would not apply to a law enforcement official, either federal, state, or local, a member of the armed forces of the United States or the National Guard on duty or traveling to or from duty, a member of an ROTC while participating in an activity for an ROTC program, a law enforcement official of another state or subdivision of another state temporarily in the state on official business, correctional officer, warden of a correctional facility in the state, sheriffs, full-time assistants and deputy sheriffs, off-duty law enforcement officials, or persons who have retired as a law enforcement official in good standing from a law enforcement agency, either federal, state, or local, condition that they possess a firearm if, or that they can possess a firearm if the official or person is displaying their badge or credential, the firearm carried or possessed by the official or person is concealed from view under or within an article of their clothing, and the official or person is authorized to carry a handgun under the laws of the state or the United States. Alternatively, those off-duty law enforcement or retired officials can carry a firearm in those areas if they are in possession of a valid permit to wear, carry, or transport a handgun issued under Title V of the Public Safety Article, and the firearm carried or possessed is concealed from view or within an article of their clothing. Another exception is that the section would not apply to a location that is not owned by, leased by, or otherwise under the control of the state or a political subdivision of the state, for the owner or lessee of the location, or a person who is authorized by the owner or lessee of the location to wear, carry, or transport a firearm at the location for the purpose of either employment as a security guard or protecting any individual or property at the location without remuneration. So they're volunteering for security services. The section would not apply to a location being used with the permission of the person or government unit that owns, leases, or controls the location for an organized shooting activity for educational purposes, historical demonstration using a firearm, or hunting or target shooting. It also would not apply if the firearm that is carried or transported in a motor vehicle and the firearm is unloaded and locked in a container that's separate from any ammunition that is suitable for use in the firearm. So those are the exceptions that apply section-wide. There is also an additional exception that pertains to sporting activities, and that is in subsection E. Provides that that subsection for organized sporting activities, excuse me, the subsection on transporting a firearm in a special purpose area does not apply to an organized sporting or athletic activity for which the wearing, carrying, or transporting or use of a firearm is a customary part of the sport or athletic activity. So that generally covers the locations aspect of the bill. If you move on in the reprint, and I just want to make sure that everybody's on the same page. The last numbered page in the reprint is bill page 3 of 3. If you go 1, 2 additional pages past that, you should see about halfway down the page, a new section 6-411. that would be getting added to the criminal law article. This section pertains to a new offense for armed trespass. If you turn to where the prohibition actually begins is in subsection C, which you'll find on the following page, provides that a person wearing, carrying, or transporting a firearm may not, one, enter or trespass on property that is posted conspicuously against wearing, carrying, or transporting a firearm on the property. Two, they may not enter or trespass on property after having been notified by the owner or the owner's agent that the person may not wear, carry, or transport a firearm on the property. Or three, they may not enter the dwelling of another unless the other has given express permission either to the person or the public generally to wear, carry, or transport a firearm inside the dwelling. Violators are guilty of a misdemeanor and on conviction subject to, for a first offense, imprisonment not exceeding 90 days or a fine exceeding $500 or both. A second conviction occurring within 2 years after the first conviction, they would be subject to imprisonment not exceeding 6 months or a fine not exceeding $1,000 or both. And finally, for each subsequent conviction occurring within 2 years after the preceding conviction, imprisonment not exceeding 1 year or a fine not exceeding $2,500 or both. A dwelling under the bill under the section would be defined as a building or part of a building that provides living or sleeping facilities for one or more individuals. There are exclusions though, generally, and that's in A2 Roman 2. But in summary of those exclusions would not apply to common areas in multifamily dwellings.
You're going backwards in the bill now.
Right. It would not include common areas in multifamily dwellings. So that generally covers the armed trespass. Right. Okay. So there are exceptions to the armed trespass section. Would cover law enforcement officials, either federal, state, or local, members of the armed forces or of the National Guard on duty or traveling to or from duty, law enforcement officials of other states or subdivisions of another state while they're temporarily in Maryland on official business, correctional officers, wardens of correctional facilities in the state, sheriffs or full-time assistant or deputy sheriffs of the state. Would also not apply to wearing, carrying, or transporting a firearm on a portion of real property subject to an easement, a right-of-way, servitude, or any other property interest that allows public access on or through the real property, or the wearing, carrying, or transporting of a firearm on a portion of real property subject to an easement, right-of-way, servitude, or any other property interest allowing access on or through the real property by the holder of the easement, right-of-way, servitude, or other property interest, or a guest of that person. So that, I think, totally rounds out the armed trespass section. Moving to the bottom of the page, that top of the page is subsection B. At the bottom, you'll see it goes to the public safety article where there's existing text, and you'll see 5301 at the bottom left-hand part of the page. If you go into the next page, this pertains to permits to wear, carry, or transport a handgun. So the first new text that's added, permits would restrict wearing, carrying, or transport of a handgun to concealed carry. They would need to be concealed from view either under or within an article of the person's clothing or within an enclosed case. Probably not. The example I'm thinking of is that in 4204 of the criminal law article, there's an exception for wear, carry, transport generally to and from certain locations. This is existing law. That exception applies when the firearm is unloaded and enclosed, contained in an enclosed case or enclosed holster. So by well, that's, I'm just giving an example of something else in the law that's an existing exception. So this doesn't provide for storage in an enclosed case.
Senator West, are you talking?
So
about-
I
you're
don't
talk-
think an enclosed holster would.
You're not
would
talking about
qualify.
storage, you're talking about like where, like if it's concealed carry or open carry. You're not talking about storage necessarily, you're talking about carry. Would a holster on the outside that's visible, or is that what your question
Well-
you're asking?
I've got a suit on, so if
Yeah.
I had something on my belt on the side, so
be
if the
concealed?
suit blows up by
It's-
the
it's-
wind, then you could see the holster.
You know,
But
I guess
normally You wouldn't see it under.
it,
Should
it's.
we need a greater definition of concealed from you? What does that mean?
It's an interesting question because, I mean, as I think about it, would a holster count as an article of your clothing if it's
Well, we want to be clear about this, so
Mark,
people don't inadvertently what they belong.
So if I may respond, that is a definitional problem with concealment. A lot of states, I'm thinking in particular here of Florida, provide for an exception for where the firearm becomes visible momentarily in exactly the sort of circumstance you're talking about, where the wind blows open your vest and someone sees it. And that would be a useful amendment, in my view, to this sort of thing. So there's not a strict liability if someone happens to glimpse the firearm that's concealed under your coat. So that is a useful idea.
So, Mr. Penick, okay.
So like the chairman's comment previously, we'd like to move these bills together to the floor. I don't think there's any particular ambiguity about concealed within the clothing. And that we need a wind blowing amendment, but if you want a wind blowing amendment, let's put it on the floor and consideration for the body when this comes to the floor.
Whether he sees any other problems with the definition of concealed from view. So we had the wind blowing amendment. Is there anything else that we should be considering?
Possible ambiguity is where the person is inadvertently printing. That means that the firearm is visible as a bulge in the clothing, and that someone who's trained to detect that can provide a reason to stop, for example, and frisk. Or a printing should not be, in my view, at least, a indication that you're not concealing it. And right now, concealed means, well, if I can tell you're printing, you're not concealing it. Well, and that's an ambiguity.
So let me ask this, in the summertime, when it's really hot outside, I mean, the wintertime is fine because you're wearing coats or overcoats and it's easy to conceal something. But in the summertime, when you're wearing short sleeve shirts and frequently short pants, how would you conceal a firearm?
I wear a long t-shirt.
Is that right? Yeah,
It is possible,
it is
Senator.
possible. Okay, fine.
It's uncomfortable, but possible.
Yeah, okay, it's, okay, fine.
So, but that does really create the situation where inadvertent disclosure or printing may become an issue. So, I mean, that kind of ambiguity, since this is a criminal statute, ought to be resolved.
Sorry, just a point of clarification to Senator West's suggestion about the wind blowing amendment. I think what I heard you say was that it was in instances of momentary, but you would want it to be unintentional momentary to sort of the positions that was raised by Senator Washington before, that things can be used as threats. If you momentarily unconceal your weapon, that could be a threat, and I would certainly be opposed to that.
To be first degree assault in the state. That is a felony, punishable up to 25 years. When I teach the course, that's what I tell my students. Don't do that.
Thank you, Mr. Chairman. So I just want to be clear because it looks like we've done a lot. I know there's been a lot of talk and we've had a lot of meetings about this, trying to get through this. And I appreciate the vice chair and the chair's ear on this and the concerns. So the public conveyance part, that's gone, correct? Okay. Just want to make sure I'm seeing, I've got like 3 different copies here. I'll make sure I got everything done. So that one's gone. The only, and we appreciate you hearing our concerns on that very much. The other, and you modified the distance from a public gathering, the building, yeah, I'm going to get to that. Would there be a consideration, because it does say, and I don't want any ambiguity in this, but when it talks about a government building owned or leased by a unit of state or local government, that is marked as such, because we have some facilities that they lease to store things that are not outwardly marked as being leased by them or being a center that is owned or operated or leased by the local government entity. I think that's important little addition to that, to say that, and is clearly and is marked. I mean, it's just asking for that clarification so people know, intent is an important element of the crime. And then under the locations, when I read the organized sporting or athletic activity, means an activity in which 3 or more individuals are part of the same league or association are competing in a sport or athletic activity together. Athletic activity leaves some interpretation there. And so one is, I know of parks around where I live, there's walking paths all around there, and ladies come together and they go and walk together, and people walk together frequently. So if, for example, say 3 spouses meet up there and they just are walking around together, and one of them, and if they're walking on the walking path, that's a physical activity that is left very much open into interpretation on that component of it. When you added the part about the musical concert or performance with members of the audience are required to pay or possess a ticket, I mean, that's a good addition. I think that gives great clarity and reasonableness to understand that that's the environment you're going into. Removing, the part about even like the movie theaters, that's another important thing. So we appreciate that understanding and that latitude, but I don't want people who are like the soccer mom we were talking about the other day in this same scenario, who has a protective order against her estranged spouse. She carries for her own protection. She's now a part of this 3-mom group, or even coaching kids there, and she leaves it in her car. We were talking about adding in an adjacent parking lot. I know we talked about that. I don't see that here. But the other component of that is the activity, the athletic activity now spins off into, she's not around people. She's with 2 or 3 other ladies. They're walking. She violates this, even though she's carrying legally for her own protection from her spouse, who is a predator. And that's the problem I'm having with that component.
Well, so are they, are the 3 individuals walking part of like a league or association together? Or are they?
No, it just says, or an athletic activity.
Right. So the qualifier to that would need to be that the 3 individuals would all need to be part of the same league or association.
Okay, so if they're a part of you don't have any clarity there for association. If they're a part of the same HOA that sets this path up, they're a part of an association. We're putting so much language into it that we're trying to get, this is what causes things getting into the wood. Like if we would focus on the issue that you're trying to do, but we're trying to get so specific, it's creating collateral damage to people being able to exercise their First or their Second Amendment right to protect themselves. And that's a concern, is that there are a lot of battered ex-spouses who are contacting our offices saying that they have concerns and they need to be able to protect themselves because they have genuine, grave concerns about the abuses they had before. And we're limiting their ability to feel free and able, like they can go out. We're restricting them from being able to be a law-abiding citizen and go out with their friends and be a part of the community. Because we don't want,
You want to?
that's what it's already in here.
It's in there. So what do you need?
It needs to be taken out that there's the part about an association or like you want to have it as
Oh,
an
you just don't want it.
organized
Sorry, I
sport and
thought
you're a part of a league.
Forgive me, I misunderstood what you were saying. You're fine.
An organized sport and a part of a league. But when you start adding in, well, we're going to do it as an association and they're competing or an athletic activity together. Well, athletic activity could be a lot of things. Yeah, I mean, that would include practices. That would include anything. That's why I'm saying athletic activity, by showing up and walking on a walking path, that's an athletic activity. Because they're there for the purpose of cardio.
All right, let's do this. So we've got at least one idea with a pin in it. What was the first idea? Council. My deal is, just so we know what we're working on, let's adopt this amendment first so we can work off of this. The bulge amendment, okay, got it, or the wind amendment, got it. All right, let me just adopt this amendment first and then we actually work off, so there are subsequent changes, yes.
I'm so sorry. And forgive me, it's because I wasn't in these hearings, but I just wanted a clarification on the amendment on the definition of area for children and vulnerable individuals.
Yep.
I am concerned, and maybe it is included in here, but I don't see it. In addition to, obviously we have schools covered under government buildings and preschools and pre-Ks, but what about school-sponsored after-school programs that are off-site? Are they covered? Like when they come and they pick you up the bus and they take you to karate camp, those types of school-sponsored after-school activities?
If karate camp, I'd have to check the definition.
Right,
of
because they're
youth
not
camp to-
necessarily licensed by the Department of Health.
Okay,
Have to answer this.
yeah, I think it would depend on, I need to go back and look at the definition of youth camp, but it sounds like.
They're not, they're not in the definition of youth camp, but
Okay.
it's a subset of extended day programs that we have across the state. They pick you up after school, they take you off site
Sure.
to a non-licensed facility.
Okay,
All right, so just before adopt this, so we can work off of this. So this motion to second, everyone's okay with that? Okay, great. Let us just make sure we're documenting some of the concerns. So we've got the wind amendment or the bulge amendment. You've got, so now we're on unnumbered, but Roman 4, subset 5, there's no page number. The organized sporting athletic activity. What would you like? What's your pleasure on?
You got the leads ones, so it has to be clearly marked. Identified as a government.
We'll talk about that in a second. I mean, I wonder how that.
To what? I mean, when they don't have the footprint and they have to use other things, and then someone goes by this, they could be in violation just by walking. Yes. But it's not outwardly marked for the public. Yes. So it just would need to be clearly marked as such.
So it's like a kind of a clandestine thing, these are, let's just say in theory that there were buildings that intelligence officers worked at. They wouldn't mark that building. They would just go there and then in their civvies. And then once they get in, it's like, they're in military uniform and all this stuff. It can't be marked because they defeat the purpose of having an unmarked building. That's kind of blends in and it's less discreet. But then you're telling me we have to mark it?
Well, I would think that if you're gonna walk in, if you're.
You
gonna
mean
hold
inside, like
accountable for
signage
walking-
inside saying, hey,
If you're gonna walk in and hold the person accountable for walking in there with it, then yeah. It's about intent. Is the intent to go there to commit a crime or is it there to? Okay, and then the other one was the athletic activity edition where I would just say you've got to strike the athletic activity altogether and just leave it as if you're leave it as 3 or more individuals who are participating in a same league or sporting act. I mean, that's I don't know why we're trying to add in athletic activity because that encompasses everything. from
No, I think we're
partying.
trying to get away from the kind of the spontaneous, like if you're just going to pick up soccer game, pick up football game.
Okay, so that you can say that an athletic act or a same league or sport where a registration fee is collected to participate. I mean, that's almost like the venue where you're talking about they're required to pay or possess a ticket to be admitted. You've got to be an included part of the body.
Bill, like I say, I think the way you have to read it though is.
Chairman, so on that same page, organized sports, athletic, if you come up to section 3, where it's talking about the locations being used as a polling place in accordance with the election law. So my question is, in the election law and being used as a polling place, is that just always, or is that just the day of the event? Because you'll have a church that might be used as a polling place, and 360 days out of the year, it's a church, and you are saying that it can't have it there?
So
Depends what your definition of is.
Once again, this is why lawyers shouldn't be on, this is why lawyers shouldn't be on JPR.
right, the wording of the language, Senator, is present tense, so it would seem that, so it
That's
is
my question, just.
being used.
Depends
It's
what your definition of is. I'm kidding, I'm asking is in present tense, so. I think-
right, the construction of that would be that it's currently being used, like it applies while it's being used for polling or canvassing.
And then the next day when it's not being used, it's okay.
Correct.
You're sure about that?
Well, I
Because
mean,
if we're
I don't
finding,
know that it needs more clarification, but that's up to the committee if you feel that it does.
I just
It's record now, is my intent.
at
All right, Senator Muse, did you have a question?
Mr.
no, not really. If you,
I've missed a lot, but I have to, oh, sorry. Everybody's got to go.
oh, I think it's been answered as clear as
You
mud.
wanna-
James, then Senator West, and Senator Bolden.
I was just gonna make the suggestion that we clarify that part a little bit more because I don't know that it makes a lot of good sense to expect law enforcement to make that distinction if we're not gonna clarify it in the law. You know, this idea about how something is being used and when it's being used. I don't think that we should leave this like subject to a lot of confusion.
Thing, right? Like, go ahead.
So during early voting for 7
Okay.
days.
Go ahead, Senator James.
I have I need two clarifications or just thematically understanding the bill. The one, I guess, really relates to the locations on the unnumbered page. I guess we'll call them the one that has special purpose areas. Let's just look at those. So my reading of Bruin and then the law review articles that have delved into special places or sensitive places is you have to look for an historical analog. And from that historical analog, you kind of have to pull out what were the salient aspects of the location that somehow ended up being protected historically. So, for example, if we did polling places and courthouses, and the salient factors of those places is citizens have to go there. The government sort of has a monopoly power that if you have a legal dispute, you need to go to court. You want to vote, you have to go to polling. So you can sort of see any building, a government building or a building in which, or a location in which there's sort of monopoly and a required activity sort of from the government. That's one salient aspect of sensitive places. The other is sort of whether law enforcement is available to protect people. And really the idea from the literature I read is that the less law enforcement might be around, the less they might be able to intervene, or the less security there might be in entering a facility, then that's when you might have more of a case to bring a firearm. So I just am wondering if, I'm sure you did this analysis, I would think, with this group. So what were the salient factors for these locations that you thought would, get the sensitive location or sensitive place treatment? That's what I'm trying to understand. And then my second one's about dwellings, which we can get to in a minute.
So you're exactly right, Senator James, and I appreciate the question, and I think your analysis, the starting point for your analysis is correct. So on page 20 of Bruin, Justice Thomas, who's the majority opinion writer, gives this example of the green hat, green truck, and that a green hat and green truck would not fulfill the obligations.
Yeah.
Under the case, they are both green, but they are not similar in an operative and important way. And so the true point of analysis is not whether they are kind of optically similar. They can actually be quite disparate. As Justice Thomas says on same page 20, Heller and McDonald came after Heller, point toward at least two metrics: how and why the regulations burden a law-abiding citizen's right to armed self-defense.
Mm-hmm.
And so here are some of the analyses that we utilized in crafting the bill to ensure its compliance with Justice Thomas's opinion and the Bruin case overall. Heightened emotion, diminished capacity, adversarial competition, comparative time-space burdens on the right, sensitive contents, and that those are the primary whys.
I'm good. It was heightened emotions.
Sure. Let me go through that
Heightened
again.
emotions, adverse
Heightened emotion.
activity. Sorry, go ahead.
Diminished capacity, adversarial competition, and comparative time-space burden.
What does that mean?
So under Bruin and through Justice Thomas, he makes the point both at page 13 and page 20 that relevant to the analysis is the extent to which the burden is matched to the burden for which you are creating an analogy. So on page 13, he says analogs did not remotely burden the right of self-defense as much as absolute ban on handguns. In other words, he is looking at the comparison between the two burdens. And where you think maybe on just page 13, that's dicta, he's just kind of throwing around some language, he repeats that affirmatively on page 20. In other words, on page 13, he says it in reverse, and on page 20, he says it in the affirmative. He says, therefore, whether modern and historical regulations impose a comparative burden on the right of armed self-defense and whether that burden is comparatively justified are central considerations. And so in utilizing the factors of analogy, we utilize comparative burden as to time and space.
I'm sorry, I still, you lost me on time and space. I apologize. Now.
So the New York law that was at issue and that was struck down under Bruin was at all times and for all space. There was no place outside of your home where you could go and be in compliance with the New York law unless you had their version of good and substantial reason. And there was no time at which that law did not apply. During the day, 24 hours a day, that law applied to you. And so it applied at all times in all spaces. But there are historical regulations that applied for a limited time or in a limited space. And so when you are comparing the burdens between two analogies, you can compare the burden as to time and you can compare the burden as to space.
Okay. Okay. And then no, I followed it. I don't know. I don't want to argue with, so did you where did you find heightened emotions? And I assume diminished capacity. I don't think you mean mental illness. You probably, or you maybe you do, but are you talking about people who've been consuming alcohol or drugs? Is that the diminished capacity?
That's right. Or whose capacity is diminished by the heightened emotion. Some of these work together.
So I guess what you're thinking is maybe at an athletic event. I don't want to, I think these are cliches, but I get it. An athletic event, maybe a stadium, some musical concert, especially if it's the Rolling Stones or something, right? People might be enjoying themselves, but also imbibing and getting them. And so that's sort of how you were using diminished capacities. I just want to understand that term.
That's correct.
Okay. All right. All right, I've got what your analysis is. Thank you.
James.
And now, oh, I'm sorry. So let's just go back. The other question I just want to go back to is dwelling on, it's not the page, but you know, it's section 6-411. Well, yeah. That's the definition. Okay, and then you go over to the next page. So I remember we discussed this a little bit. I understood C1 and 2 because you are working to enhance trespass laws, trespass penalties. If someone is, you know, carrying a gun, are you doing the same in C3? Are we tying that to trespass?
That's all part of the same. I mean, it's not named in the statute, but armed trespass offense. So
Speak up.
that's all part of the same section or prohibition. So it's 1, 2, and 3 would all be part of the trespass statute, and organizationally, it would be in the code under the trespass subtitle, I think.
I guess the reason I'm asking is that, you know, in C1 and C2, you're clear that you say enter or trespass. And then why did you choose not to say enter or trespass in a dwelling? And that's why I'm concerned that it's not tied as tightly to trespass, which I think would be upheld, probably upheld or has a better chance of being upheld. But I don't think it'll have as good a chance if you don't tie it to that, because I think it's pretty clear the government cannot enforce a private property owner's rights. That's probably not quite the way you should do that. So I'm trying to figure out what you did there.
I couldn't answer the why, Senator, but I could tell you that the nature of the offense changes when we're talking about entering a dwelling. All that's required in 3 is that the person be wearing, carrying, or transporting, and that they enter the dwelling. So it's distinct from the other 2 modalities.
But then are you saying elsewhere in the statute that C3 is a trespass or a crime?
Well, it would be categorized in the statute as a trespass, and they're all crimes. I mean, we're talking about criminal trespass. So I think just as a matter of organization, that's how that ends up being.
I mean, I just want to be very clear. In C3, even you've left out the word trespass, but it's your position nonetheless that C3 is a trespass. I mean, if you don't follow C3, it's a trespass for which you can be held liable criminally under this statute. Is that right?
Well, I think that it carries right. If you are entering into the dwelling of another, you don't have permission from the other, either specifically or generally, because they've given the public generally permission to enter with firearms. Then just organizationally, it's categorized as a trespass offense and would be in the code. I guess, is it more of a sort of in theory, sort of question in theory as to the idea of trespass being that you are physically going someplace where you're not supposed to be going, Senator, versus something else that's criminally prohibited? Or is that the distinction that you're asking about?
I want to make sure we tie it to that we intellectually, legally tie it properly to trespass, because I think the case law is pretty clear and the commentary is pretty clear that the state does not have a right to enforce and criminalize a private property owner's right to decide who comes on and off of their property.
Gotcha.
We can do
So
that.
I'm
We
worried
can-
about the
we can-
language of that,
That's a good plan.
Yeah, we can do
that
that.
it's just not gonna pass scrutiny.
We're gonna,
or review.
we'll work on language for that. That's right.
Okay, thanks.
Okay, thank you, Mr. Chairman. So I don't want to add more suggested changes, but I did want to make a statement about the bill before we vote on it. Is this an appropriate time? Yeah, yeah. Sure, yeah.
Thank you, Mr. Chair. So I just have two last things here. Yeah, so the one is the special purpose area where we talk about a location under special purpose area. It says a location licensed to sell or dispense alcohol or cannabis for on-site consumption. So I don't drink, but if I go to a movie theater that sells alcohol, they're in violation of this. I don't drink. I go to Outback with my family. I'm in violation of this because they serve alcohol there, even though I don't drink and no one at my table drinks. So that's a very broad area that brings into a question a lot of, there's a lot of concern for that because there's a lot of places that are serving alcohol, and I appreciate the reason behind it. I don't know that it's altogether properly put in place for someone like myself who doesn't drink, who takes my family out to eat. And because they sell beer, wine, or alcohol there, it would be a violation. Did you have something to add, Mark?
We all understand that. This is a policy, not a legal thing. So I mean, we'll continue the banter. I mean, if the vice chair wants to weigh in or no.
Well, I'd like to hear what Mark's got to say about it because the concern is that when you're doing the alcohol, it just says specifically a location licensed to sell. It doesn't even say that they got to be selling it at the time. It just says you got to have a license to sell it. And if they have a license to sell it and I'm there at the movie theater, I'm not going in there drinking. But
what are you hoping to glean from Mr. Penick?
well, I think it's
because we know the policy. I mean, what are you asking? I mean, good.
Well, I'm asking that's in there, and you're people that don't drink that are responsible gun owners potentially are going to get themselves in trouble by carrying within their legal right to a place that dispenses, that has a license, may not even be doing it, but they have a license at the time. And because of that, there's going to be, I could be arrested and lose all that. Right. I mean,
States, and I'm thinking here in particular, Virginia, ban the consumption of alcohol when carrying completely.
boom.
And we're fine with that. Other states ban carrying in bar areas of a place like Applebee's. So that those individuals can't be at the bar.
How does that work functionally? Like for consumption, someone has to witness you and then they have to report it to somebody.
But there's
like if you're in an establishment, is like a waiter or a waitress gonna like report this to the management, and the manager's gonna be like, hey, look, like I saw you drinking a beer. If you're carrying, you gotta go. And now we have concealed carries. We were making it, everything's gotta be concealed. So how would we know you're carrying? I mean,
well, if they see it, but that's the thing is that if they are there, this is a part of the education part that comes in through the firearms instructors. And if they carry said weapon in an area that they are drinking and knowing that that's a violation, then that's on them. And then law enforcement can come out there and take the appropriate actions. I wouldn't ask people to, go up and tell them to leave because they got a gun on. I mean, if they choose to, that's on them. But There's a reason behind this. And the idea that if you're there and you're drinking and armed, yes, that's not a problem. But if you're there in an establishment that's simply licensed to sell alcohol, and like me, and I don't drink, but I go there for dinner with my family, I can't be restricted on being able to carry in and out of there because of someone else's illegal activity, and there's consequences for it.
Just, and I love my friend Senator Folden, but we see this differently. I would say it's not a problem until it's a problem. And I would err on the side of caution here and say that any commercial establishment that has gone to the effort of applying for an alcohol license is therefore making a choice at that point that they don't want people to carry weapons into that establishment. And the commercial establishment doesn't need to make that choice. They could choose not to apply for a liquor license, and that would be their choice as well. But I would be really concerned because of the points the chairman raised. It's not a problem until it's a problem. And if there's alcohol consumption on site, the potential for a problem is increased. So that's my concern.
So in response to that, by that, people get alcohol licenses because that's where they make all their money for profit. If we go to the movie theater because they sell alcohol at a theater, you're saying that even if I go with my children there, I'm not allowed to arm and protect myself because someone else chooses to go there to drink.
Not every theater in the state of Maryland has a liquor license.
I understand that. I understand that. But what I'm saying is this is where we're getting into the constitutionality of someone being able to legally wear their weapon, sober, responsible, trained, versus we're not. I wish we were having this great discussion about all the illegal gun ownership that's going on around here. I really do. But we just seem to push that away and not want to handle that. But we keep coming back to this. And if we don't have this running rampant of someone carrying their gun into Outback and taking their family out and who isn't drinking and being able to protect in the event that something terrible go bad to protect their family. That's what we're talking about here. And the idea that we're going to strip that just arbitrarily because that place sells alcohol
I
inside.
think it's arbitrary. I don't want to get in a back.
It is arbitrarily by what you just said.
Well, I'm saying the point that makes it not arbitrary is that the commercial establishment chose to apply for an alcohol license. That's
But
how I
doesn't-
see it. We have a difference of philosophy
I understand, and I
yeah.
appreciate that,
I
but
just don't see it
because
as
you
arbitrary.
apply for an alcohol permit doesn't mean you automatically are telling people, oh, well, by the way, we're going to violate the Bruin decision for you. Oh, my last point is, I'm sorry. My last point is on, for a second or subsequent offense, we picked a number of 456 days or a fine not to exceed $7,500. I'm just curious where that number came from. If that was a typo or if that's. Sure, it's on the, shucks, it's after. What is, I don't even know what page it is. It doesn't say. It's like, let me see. 1, 2, 3, 4, 5. It's on page 6 of the original bill, not the amendments. And when you go down, the top of the page says government or public infrastructure area is the very top line. And then you go down about a third of the way, G subsection 2, for a second or subsequent offense, imprisonment not exceeding 456 days. And then also under section 2, not exceeding 456 days.
15 months.
Oh,
Yeah.
okay.
No,
Hey,
we actually flagged that one. It's funny.
okay, all right, thank you. That's all I needed.
Number one, I want to compliment the sponsor of the bill, the chair of the committee council for turning a bill which started out as being just completely over the top and overwhelmingly unconstitutional into a much improved bill. The problem I have is I took an oath to support the Constitution of the United States, and I will not vote for a bill which I believe is unconstitutional. I just won't do it. And there are certain respects in which this bill remains unconstitutional. Let me just isolate a couple. First of all, the list of ethereal considerations enumerated by the vice chair of the committee, you can't find any reference to that in the Bruin case at all. The Bruin case is really quite specific. there's nothing about heightened emotions in the Bruin case. The Bruin case, the key language, which all 6 of the justices who subscribed to it agreed to, is as follows. When a challenged regulation addresses a general societal problem that has persisted since the 18th century, the lack of a distinctly similar historical regulation addressing that problem is relevant evidence that the challenged regulation is inconsistent with the Second Amendment. In other words, if there was nothing in effect back in 1791 that addressed a general societal problem, then trying to enact such a regulation today is not permissible under Bruin. So I've just isolated a couple of elements of this bill which illustrate that problem. There were bars back in effect in 1791, but no one has pointed me to any general regulation existing in 1791 which prohibited people carrying firearms into bars. I don't think it happened. Remember, in those days, you didn't have parking lots with cars. If you arrived on your horse at a bar, you tied your horse up outside. You didn't leave your firearm in the dirt outside. You carried it into the bar with you. Racetracks, which are covered by this bill, there were racetracks back in 1791. Nobody has suggested that there were any regulations in effect in 1791 prohibiting firearms in racetracks. I'm quite sure that people carried firearms to racetracks all the time. Live theater performances. There were live theater performances back in 1791, and I'm not aware of any laws of general applicability in any state that said you can't take a firearm into a live theater performance. Public gatherings. There were lots of public gatherings back in 1791. You think of the Liberty Tree up in Boston. I suspect a lot of people in Boston had guns at the Liberty Tree. And then finally, I've just cherry picked these from the bill. I could go into greater detail. Off-duty law enforcement officials. We had off-duty law enforcement officials back in 1791. I'm not aware of any regulation that said off-duty law enforcement officers are not allowed to carry their firearms. So it was suggested earlier on that the concurring opinion by Justices Kavanaugh and Roberts may have set up a separate standard. That concurring opinion is only 3 pages long. I've read it backwards and forwards. It does not set up a different standard. The concurring opinion over and over, several times, refers to the majority opinion. I said it starts, the court employs and elaborates on the text, history, and tradition test. And then it goes on, it says, applying that test, the court correctly holds and continues on. This is not a separate parallel standard. This is the 2 concurring justices discussing why they agree with the majority opinion and the standard set forth in the majority opinion. To suggest that the concurrences sets up a different parallel standard, which is not the same as the standard in Justice Thomas's majority opinion, is simply wrong. So for those reasons, I'm not able to support this bill because I find it's unconstitutional. And I think that shortly after this bill is signed into law by the governor, as it surely will be, there will be a challenge in court, and the courts will find the bill unconstitutional and enjoin its enforceability. So I can't vote for this bill. Thank you.
Thanks, Senator West. I'd like to read a bit of advice that we've received from the Attorney General that speaks exactly to your concerns. But before that, let's go to Senator Folden, and then we'll go to Senator Walter. Senator Folden, and then
I get it. I just want to have it read into the record, since we're having this discussion, that I discussed this with you in council. I discussed it with both of the panelists from both sides of the issue about the modification to the organized sport or athletic activity section. That if it was modified to say that an activity means an activity in which 3 or more individuals who are competing in a sport or athletic activity together as part of the same league. That would imply that they all have registered, that they're part of it, and that they are actively involved in that activity and sport together, and would exclude the moms and the people that I'm concerned about that have ex parte orders. So. Thank you.
Well, we could actually amend the amendment. Or no?
Just do it all one.
Okay. So you just add it to the floor amendments?
Yeah, but if you could read it back.
Okay. So Senator, let me know if I'm got this right. Organized sporting or athletic activity means an activity in which 3 or more individuals are competing in a sport together as part of the same league. Did it?
I'll come.
Part of the same league,
Sport or athletic activity together as part of the same league.
correct.
All right, we had Senator Kelly, then Senator James.
Sorry, I'm fine with what Senator Folden just suggested, but I wanted to know if we could possibly add into the children and youth section then the language about a school-sponsored after-school activity, whether it's on or off-site, which would cover those programs that are not licensed.
With that, so what we're gonna do is, we're gonna do, these are floor amendments that we're gonna do, so.
I thought you were saying we were amending the amendment. Okay.
I just want to go back to the vice chairman and sort of clarifying, and Senator West followed up on my original question about what criteria you used. I guess when I looked at the law review article, there was an aspect, at least historically, of restricting guns if someone was terrorizing the public. But short of that, which I think is what you're sort of aiming at with these locations, because I think what you're doing is looking at the locations and thinking the people, because there's nothing inherently wrong with the location itself, but you're assuming that the activity or the people that go there would be irresponsible in one way. Either they would be unable to control their emotions, they would become violent, I guess, or the propensity for violence. They might over imbibe in substances. So to me, it would make more sense if you were trying to tie this restriction to people's conduct, which we do somewhat with the permitting process. But again, sort of following up with Senator West, I hear your criteria, but did you find any historical analogs that kind of consume that idea of what people were doing, that people were acting inappropriately? So I'm trying to figure out whether you're tying it to people's conduct and any cases you can find there, or were you trying to tie it to locations? And, maybe you could give me an example of how you found it that way. Because to me, you're focusing more on the people. And I'm wondering if there were any historical analogs regarding people's conduct under certain circumstances.
Thank you. I'll answer the question, then I'll kind of summarize from a policy point of view. Let me reiterate that that Bruin does allow a concentration on places, not necessarily on people, and identifies certain places as examples of places that are inherently lawfully sensitive. And it identifies a number of places. This list is not exclusive, but it includes schools and government buildings and legislative assemblies and polling places in courthouses. When you are in those places, you do not have to be terrorizing or with the intent to terrorize or affray for the purposes of being cited for criminal behavior. You cannot be in those places with a firearm. It doesn't matter whether you intend to terrorize or not. And so I reject the idea that Bruin or Heller and McDonald before it do not allow regulation as to places and only allow regulations as to people.
Oh, I didn't say that.
Okay, I'm sorry.
That's not what I said.
And so
I was
I
asking
wanna-
for historical analogs to justify the criteria that
That's
you
right.
gave me, and I told you what I thought the elements were. It was whether there was a monopoly. Everything place you cited,
Yep.
there's a monopoly by the government. You have to go there, and you're compelled to go there, and or law enforcement is not readily available to protect you, or you're not going through a screening or something like that. I'm almost inviting you because I think I could make an argument for a couple of your locations, but so far I was just seeing if you could.
Yes, I appreciate what you're saying. I want to go back to the quote I gave you earlier, which is at page 20, that Heller and McDonald, this is the direct quote, Heller and McDonald point toward at least two metrics: how and why the regulations burden a law-abiding citizen's right to armed self-defense. And so the relevant inquiry is not the green hat, green truck. Are these two twins? Are they analogous as to type, but are they analogous as to reason?
Right.
And so I provided those reasons. You've provided additional reasons. The court in Bruin does not list either exhaustively or really at all what constitutes acceptable how or acceptable why. And I think we are open to the idea that this is subject to litigation. But I think the reasons you provided are valid. And I think the reasons we listed as a basis for the how and why justifying the sensitive places in the bill are also appropriate reasons. And will
There was a
withstand
really
court
good
scrutiny.
law review article that truly invited legislators, if they would read the article, to go ahead and make clear in their bill the criteria they're using and their aim. So the reason I was trying to get a dialogue with you
Yes.
about this is the law review articles that I've read absolutely identify the elements, not the location, but the elements for the locations already cited in Bruin and what was so important about them and why they've emerged. And other law review articles, if you read them, or analysis, have talked about, look, legislature, take this case seriously and try to put forth in your bill, showing why you are choosing what you're choosing. And without you telling me, I did not see any of those connections. And even now, I'm not sure about them, but
Well, I
least-
agree with everything you've said.
Okay.
About the necessity to both document and provide reasons. And I think the chairman in his concluding remarks will talk about the Office of Attorney General and their view of these things. But let me kind of conclude myself on a policy note, but also jumping off of what you said. When Heller came down in 2008, it banned the DC government's law against home defense. You couldn't have a gun in your house under DC law. And when Heller was decided by Justice Scalia writing for the majority, there was a sense among gun control advocates that Heller was historically destructive to gun control laws. But that turned out not to be the case. And over the next 15 years, what people realized is that the Heller case provided a roadmap for an appropriate regime to limit guns in our community. Heller was itself the means by which new laws and old laws could be defended in court, and policies like ours across this nation could be passed. Bruin is the same. We are not passing this in spite of Bruin or to go against Bruin. Bruin itself provides the rationale and the roadmap for further policymaking. And the bill in front of you is squarely within the guardrails that Bruin provides. And that's why I think the bill is so important, because it is within the legal guardrails, and it is us providing societal guardrails, reasonable guardrails that affirm Bruin's case, but then nonetheless makes very clear about where guns are and are not allowed as to sensitive places and as to private property. And on top of that, we didn't kind of walk through this portion of the bill because I think it's widely supported. It also further delineates who is allowed to receive licenses under our statutory scheme. Given that we now have, 80, 90,000 people who have applied for such licenses since the Bruin case was decided. And so I think this is good policy. I know it's good policy. I think it's important policy, but most importantly, it's policy that utilizes the tools provided us by Justice Thomas in the Bruin case itself. So I urge a favorable report on the bill as amended.
All right. So just a caveat here, can we pull up the list real quick of the things that were identified? So I know we need to move the bill on, but there'll be some forthcoming work ahead. So Jamie, could you just read? I can't read that.
So on the list that I have, it would be amendments to dealing with exceptions to the concealment requirement for I guess printing on somebody's clothing or inadvertent lift of clothing which exposes a firearm. Floor amendment to change the definition of organized sporting or athletic activity. That floor amendment pertaining to conspicuously identified government buildings or and tell me if this is incorrect, conspicuous signs on government buildings pertaining to firearms. I'm not sure how the committee would like that worked out. That it is a government building. Polling places, there seem to we're gonna sort of clarify that it is currently is being used as a polling place as opposed to that it just is being used as a polling place. I guess further work on trespass of dwelling. So that would be that number 3 or item 3 on the armed trespass statute. And then further clarification on the prohibition on alcohol licensing or alcohol and cannabis establishments or something related to. So it would be right. And this is just sort of highlighting the areas that you guys have talked about to consider for floor amendment. So that certainly that floor amendment, I guess, could take the form of prohibiting somebody from consuming alcohol or drugs while armed with a firearm or wearing, carrying, or transporting a firearm.
That's what we're trying to do here. But here, I mean, I'm going to be honest. My big concern is we have a body that has discussed this ad nauseum at times. And we're now going to go ahead in a rush to move this forward without having these elements clearly articulated and agreed upon. And what's to say this doesn't go out to the larger body and they're like, you know what? We don't care. Everybody in this body everybody on this committee has put in a lot of time and hours to make this the best it can be, regardless of what side you're on. And I think that the end product should be from this body to move forward without any amendments from within the committee. And I just think that it's about, we're banning physical locations rather than behavior. That's what I wanted to try to get to the point of, hold people accountable. No one on either side is saying don't hold people accountable for these illegal acts. But when we're just, the part about the drinking or doing cannabis while in possession, that should be the delineating factor. It shouldn't matter where. That should be the factor. Can't carry it if you're doing it. So it's a simple line. And then the other part is for persons that are, when we're talking about we didn't get to this really, but the training part, we spoke about it the other day about the training for the de-escalation and the law for what they want specifically covered in the state of Maryland. There's no guidance given for these instructors, firearms instructors from across the state. So you're going to have varying degrees of what they feel is appropriate and what's not. And there's no guidance given specifically from any training division of state police or anyone. And I can tell you that they are not allowed to teach as instructors as a component of law without giving set guidance.
Yeah, I think
so. There's a legal liability there for sure.
I appreciate everything you've said. We've got six elements that we will work through. I have to advance this bill to today, but we are, just as in the safe storage law, we'll prepare that floor amendment. The work on this bill from this committee is not done. We will work on this, and it'll be.
It seems like it's done after this vote.
It's not. I'm telling you, it's not. I have to move this bill along, but the 6 elements that we've teased out here, we will continue to work on as a committee and have a floor amendment ready for it.
I wish there was that type of urgency on other bills.
We will have the bill laid over until we can get these things sussed out. Senator McKay.
Mr. Chairman, I have to agree with Senator Folden over there. This is not ready. As much as I respect, as we've been working on it, I think we've got time to continue to work on it. And, you know, one of the things that just came to mind was this all doesn't apply to retired police officers. Why is that a special class? Why is a retired police officer a special class and other people aren't? And I say, are we creating another red line issue? Where we're redlining a certain class of people because they're not police officers? I mean, at the end of the day, either everybody is given the opportunity to have a carry conceal permit under the way Bruin has come down, or we're just picking classes. So I just, that's a new area that's come up to mind that I'm just very concerned about moving the bill, sir.
Okay, we've got a motion for favorable and seconded with amendment. We do a roll call.
Vice Chair Wildstriker,
Yes.
Senator Sidnor,
Yes.
Senator West,
No,
Senator Muse.
Yes.
Senator Folden,
No.
Senator James.
We're voting on the amendment, right?
On the bill.
Oh, we are in the bill?
We're moving the bill.
Then I just want to say, I'm going to trust what my chairman and vice chairman have said, that I think there are 4 or 5 areas of the bill that need to be worked on. And I hope very much that you'll actually strengthen your, how you're going to defend certain places. And with that, I vote in favor. Thank you.
Senator Washington,
Yes.
Senator Kelly,
Yes.
Senator McKay,
Nay.
Senator Carter,
Yes.
Chairman Smith.
Yes. Bill passes 8-3 as amended. All right, the work is not done on those 2 bills, so I promise you that. All right, with that, that'll conclude our voting session for the day. We're going to take a 5-minute break and then we'll reconvene for bill hearings.